Hey, everybody. Attorney Bill here from WPH Law. And today we are going to be talking about credit card litigation and credit card litigation defense. What Sarah and I are going to do is just go over some of the top questions that I get asked a lot by clients who have been sued by credit card companies. So, Sarah, take it away.
I have some questions about credit card litigation. The first one I have is, do I have to show up in court?
The answer is yes, unless you want a default judgment entered against you. If you don't show up to court, then it doesn't just disappear. The proceedings still go on, and if the plaintiff shows up, which they're probably going to do, the judge will just enter a judgment in their favor without you even being there to raise any kind of defense. So they're not going to drag you out of your house and into court, but you really should go.
Can they really sue me for this?
Oh, yeah, absolutely. They can and they do. And these creditors, they sue by the hundreds, if not thousands, of cases all over the Commonwealth of Pennsylvania every year. Basically, what a credit card litigation matter is, it's breach of contract. That's you promised to do something, they're alleging you didn't do it, and it cost them money. That's really those are all the elements of a breach of contract, or most of them anyway. So yeah, they can definitely sue you for it.
At this point, if I'm officially being sued by a credit card company, is it too late to fix it?
No, it's not. If you've just been sued and you've gotten service, whether it's the magisterial district court or the court of common pleas, then you still have the opportunity to raise a defense. In fact, it's a constitutional right for you to be able to raise a defense to these. Really, the only time it's too late is if there's been a default judgment entered against you and there's the 30-day appeal period is up. Then you're kind of stuck with the judgment. Now, we can attempt to settle the matter before there's judgment execution. So you still have a little bit of life into you, a little bit of, a little bit more kick, I guess. Really, the only time it's really too late is if you're calling me and your bank account's frozen because they levied it.
Can I go to jail for this?
No, absolutely not. And I get that question a lot, actually. People are worried that if they don't show up to court, they're going to be arrested, or if they lose, they're going to go to jail. Now, credit card litigation is a civil matter. So there's only civil, quote unquote, penalties involved. And what I mean by that is if you lose the case, the judge says, okay, you owe this credit card money and you have to pay them. But if you're not going to go to jail, you're thinking of criminal matters. So whatever else you're stressed about, you can take that one off the list.
Exactly how much time do I have to respond to them?
So it depends on where you've gotten sued. Let's start with the magisterial district court level first. And this governs actions from $12,000 down. So from $1 to $12,000, that's where the magisterial district court jurisdiction lies. And a lot of credit card cases start their lives right there. Typically, they have to give you good service on you within 10 days of the date of the hearing. If they're too close to the hearing, then they have to reschedule it for another default date. Usually they're okay with getting you service beyond that 10 days. But that can kind of vary from, say, 20 days, or 15 or 10, or maybe even longer, depending on how busy that court is and how far they've scheduled out the default date. In common pleas, it's a little bit more regulated. Once you get served with your lawsuit, you have 20 days to file a response. Now, that doesn't mean on day number 21 that they're going to enter a judgment, but you start to be in the danger zone a little bit there. And this is what I mean by that. After day 20, the plaintiff has the ability to start the process for a default judgment in common pleas. Now, it's different in common pleas than magisterial district court. Magisterial district court, a date comes and goes. You don't show up. You don't give them a notice that you're going to defend this thing. Then default judgment, automatic. In common pleas, what the plaintiff has to do is they have to give you a 10-day warning. Hey, if you don't answer this complaint, we're going to enter a default judgment. Now, it's 10 days from when they actually mail that to you. So if they are, Johnny on the spot, Dave number 21, they're sending that 10-day notice out, then in effect, really you have 30 to 31 days, at the absolute maximum there. But sometimes, particularly big credit card uh, collection law firms, they're really busy. They got thousands of cases in a pile. They may not get to your 10-day notice until 15, 20 days afterwards. So that buys you a little bit more time. I wouldn't trust that, though. I wouldn't wait. As soon as you get this complaint, whether it's district court or common pleas, you got to reach out to me.
Do I really owe the full amount that they're claiming?
Well, that's for them to prove. Remember, in Pennsylvania, the burden of proof is on the plaintiff. So it's their job to prove through evidence, documentation, etc., that you owe this full amount and that the amount as calculated is what was agreed on by the parties. It's not just the use of the card that bought the TV set or the groceries or whatever it was. It's interest, it's fees, it's penalties, it's all these things that jump on each other and build and build and build. They have to show that the terms of the agreement, the contract, those types of fees, that interest rate, etc., they were agreed upon by both parties. That you said, okay, I agree for you to charge me 20% interest or whatever insane nonsense they're charging these days. So they have to prove all that, and they have to prove that their math works. And you have it's not your responsibility to prove that you don't owe it. Now, depending on the creditor, they may have, all the monthly statements that you've ever generated going back to the beginning of the card. For a third party debt buyer, that's going to be a little bit more difficult for them. And with third-party debt buyers, it's important to remember that not only do they have to show that you, in fact, owe all this money, they have to show further that you now owe it to them because they validly purchased your account. So, the answer is it depends, but it's on them to show it.
Can they take my paycheck or money out of my bank account?
So they cannot go after your paycheck. In Pennsylvania, wage garnishment is not an option for really most debts, but in particular, consumer debts like credit card debt. What they can do is they can garnish your bank account. So really, all the no garnishment thing means is they can't go to your employer and swipe your money before you get your paycheck. They have to wait for it to hit your bank account, and then they can take it. Now, there's some defenses you have if they try to garnish your bank account, depending on the type of funds that are in there, with the source of them. So, say Social Security, that's exempt from execution; they cannot touch it. Certain retirement monies, pension, etc., they can't touch that either. If it's a marital account and only one of the spouses was on the credit card account, that account is that's off limits because it's held by the entireties. That's how married people own property, including bank accounts here in Pennsylvania. But if you have money in there and you don't have any of these defenses, yeah, they can go in and they can take all but $300 out of your account, which can be pretty scary when you wake up one morning and not only do you not have access to your money, but your account now reads negative 5,000 or so. That's the judgment that's been added on as your bank assumes that that's going to be, they just take that right off of your balance and now you're in the negative.
What happens if I lose the case?
So if you lose the case, there'll be a judgment. What I mean by that is, you lose the case and you either don't appeal or you run out of appeals. Typically, these cases tend to stop at the bench trial level and common pleas. They don't usually go to the superior court, which some of them do, and everybody has the right to go to superior court, but it's a cost benefit analysis with all of these things. If you're talking about a $2,000 debt and you lose, it's really worth it to take it that high. So if you lose the case, there's a judgment that's entered against you. Well, that doesn't necessarily mean that $2,500 or whatever the judgment amount is going to magically show up in the creditor's bank account. No, they have to take additional steps called judgment execution. There's liens against real property in the county the judgment was entered. That's automatic here in PA. As we talked about before, they can put a levy on your bank account. They can send you interrogatories in aid of execution. And basically what they are is they're just questions that the creditor says, hey, where's your stuff? You owe us money. We want to sell your stuff. You got to tell us where it is. And the court can compel you to answer those questions. So, a judgment, it's not great. But it's not you're going to be out $5,000 tomorrow. And we can use that to engage the creditor even late, and try to work out some kind of a reasonable settlement where they get paid, either all at once if you can do it, or on a monthly basis if you have the ability. And from their standpoint, it's kind of a bird in the hand. If we're offering them money, they're wise to take it, versus the two in the bush where you may not have any executable assets. Bless you.
Thank you. Can I settle instead of going to court?
Absolutely. Absolutely, you can. You can settle before you go to court. You can settle on the day of court. You can settle when trial is upcoming and where everyone's just kind of waiting around. Absolutely, you can. The question is how much are they going to take, or how much off of the balance are they willing to settle for, and how long of a period of time are they going to give you to pay a settlement back? There's obviously a difference between $5,000 paid over 12 months and $5,000 paid over 24. That monthly payment goes down significantly, in that case, by half. So what you and I would do is we would coordinate your financial situation, your monthly budget, and get an idea of how much per month could you reasonably and comfortably afford to pay towards a settlement if we're going to engage the other side in settlement negotiations. And then from that point, once I have that information, I sort of do the math in my head and I start making proposals to opposing counsel.
What if I never signed anything?
So a lot of people bring this up, and it really doesn't matter. What they can do, and nowadays, very few people sign anything anymore. It's all these applications are online. There's really nothing that has your written ink signature on it. But Pennsylvania law holds that simple usage of the account can itself create a contract. So if they've offered you credit and you've used it and you've paid on it, you are deemed to have agreed to the terms and conditions of the underlying contract. Even if you never sign anything, they can use your behavior against you.
Can I just file for bankruptcy?
It's an option, certainly. It's not there for everybody. So I think the question, can you just file for bankruptcy? It's not. Again, the answer is it depends. It depends on your financial situation. It depends on how much equity you have in your property. It depends on how much unsecured credit card debt you have. If you do a Chapter 7, which is essentially a complete wipeout of, it's the clean slate. It's the wipeout of all of your unsecured debt. There's limits to who can avail themselves of that. You can make too much money. You can have too much value in assets for it to be feasible. Remember, in Chapter 7, the trustee can sell your property and use the funds from that to pay off some of your creditors. Now, there's ways called exemptions that you can protect that property. But if you have a lot of equity, say in your house or your car, and it exceeds the exemption amount, then you're at risk for losing that asset. And if it's your house, obviously you don't want to do that. The other option is a Chapter 13, which allows you to keep all of your property, but you got to generate a plan between 3 and 5 years long to help to say, okay, I'm going to pay my creditors back at least something. Problem is that if you have, again, a lot of equity in your house or your car or whatever, that plan is going to have to pay off every dime of your debt, plus attorney's fees, plus trustees' fees, and so on. So it can get pretty expensive. And a lot of times what I find is that people, they can't afford, they're in this kind of middle limbo kind of area where they have too much in equity. They'll have to then pay back too much in debt over between 3 and 5 years, but they don't make enough money to be able to afford the plan to do that. And if you present a plan that there's just no way on earth you're going to be able to do it, the trustee or the creditors are going to object to it, and the plan won't get approved. So that's it's a little bit more complicated than saying, hey, I have debt, I have a lot of it, I'm going to declare bankruptcy. You can do it, and definitely talk to me about it, but it's not going to be automatic. There's things we'll have to discuss.
Do I have any defenses?
Oh, absolutely. Even against original creditors, there are some defenses, and these defenses get into the weeds of contract law, and whether the right to accelerate a balance has been shown. And what I mean by accelerating a balance, there's Pennsylvania case law to suggest that unless you've explicitly given the creditor the ability to say, okay, you're in default now. It's not just you owe us all the past due monthlies. Now you owe us the entire balance of what you've accrued through use of the card. There's a case out there, and I've used it to some success, to say if you don't have that in writing, then the plaintiff is limited to what they can recover only to the monthly statements that you've missed. So let's say they were $100 a month. You've missed 4 months. They would be limited to $400, even though your actual accrued balance might be something on the order of $5,000. That's a nuanced argument that, if a judge or an arbitration panel is really engaged, they're going to follow. And again, it's superior court precedent, so it's binding on all the lower courts. But there are some judges that will just say, you probably owe the money. I have all the statements. Your judgment for the plaintiff. So it's important that an attorney go in there and be able to really forcibly advance that argument, because it does get into the weeds quite a bit. For third-party debt buyers, the defenses are even more robust. And I don't even think about settling with a third-party debt buyer until our backs are against the proverbial wall. We mentioned this before. Not only does a third-party debt buyer have to show that you owe this specific amount calculated this way, but they have to show that they validly purchased your account. If they don't show that, they haven't shown standing to sue. And particularly on the district court level, the way that they would show that they have this, that they have standing, that they purchased the account, is through a document called a bill of sale. Well, they have a hard time getting that document admitted into evidence on the district court level, because they almost never bring a witness to authenticate it. And what they try to do is they try to use this peculiar little rule of district court called Rule 321. It allows certain documents to be able to come in, the need for an actual living, breathing human being to authenticate it. Again, they don't have that person, so that's what they try to use to get these documents in. The issue is Rule 321 is limited. It only applies to certain types of documents. Guess what kind of document is not among them? Bill of sale. So if they don't have anybody, we say bill of sale, it doesn't come into evidence. They don't have standing, judgment for the defendant. And there's a number of other defenses based on some superior court precedent that can also potentially exclude the monthly statements. But usually that lack of standing is that's the headshot, that's the dagger, and we don't really have to go too much further beyond that in most circumstances. So, you have defenses and you should use them.
What happens to my credit during this time?
So if you're at a point where you've been sued, chances are you've been behind on at least that card, and in my experience, a few others. So your credit is going to be taking a hit long before that complaint comes in. So Uh, Obviously, once you've been sued, it now becomes a public record, which is another derogatory on your account. So you'll have a bunch of missed payments, some past dues, some delinquencies, charge-offs, sent to collections, and then lawsuit. Each one of those is a derogatory mark on your credit. If you pursue bankruptcy, that's a pretty big one. So if you're thinking of bankruptcy, that's not something to be entered into lightly, especially if you anticipate needing credit at some point in the near future, buying a car, buying a house, student loans, that kind of thing. But that's all those things are things that we can talk about in that consultation. So, going into credit card debt and missing payments and being sued, yeah, it doesn't do your credit any good, really. The upside is that if we do either win the case or settle the case, then that has to be reported as well, and that balance will come down to zero, or it'll start showing monthly payments again as part of the settlement, and it'll show the balance finally starting to come down, and then that actually helps your credit a little bit. Further, these things for missed payments and those kinds of derogatories, they only sit on your credit for about 7 years. Bankruptcy is 10 years. As you get further along, they have a less and less of an impact. So in years 5, 6, and 7, it's going to be a little bit less of a knock against you than it would be in, say, years 1, 2, and 3.
Can I win this?
Oh yeah, absolutely. And we touched on this before with the defenses. You need an attorney though that knows not only the arguments to make, but can anticipate the response from opposing counsel. Because a lot of most of the time the other side, they're not just going to say, oh well, Mr. Harrington has a really valid point. I'm sorry for even being here, Judge. I wish it happened that way. It does not happen that way really often at all. I mean, they do try to earn their paycheck, and you have to know how to respond. And the attorneys on the other side are smart. I mean, they come up with some pretty clever arguments to try to get, say, for example, a bill of sale in under Rule 321. The plain language of the statute says of the rule says no, it doesn't come in. But there's some people who try to characterize that bill a certain way and shoehorn it into Rule 321, and you have to be ready for that. I've heard that argument. I've responded to it. I know how to defend against it. So absolutely, you can win this, but you should hire an attorney to really increase your chances of that happening. I definitely offer free consultations. This makes the most sense. I want people to be able to feel comfortable sitting down and going over all of the details of their case without having to worry if they're on the clock or if the meter's running or anything like that. You can get a hold of me by phone, 484-459-5075, through my website, wphlawoffices.com, or email, which is bill@wphlawoffices.com. One thing I want to say before we wrap up here, you have defenses to these. It's okay to not be okay, but don't let your fear get in the way of you asserting your defenses. You have them, use them.